RIN TV coverage of the 2015 NRRA conference is brought to you by the National Risk Retention Association. While the Liability Risk Retention Act was passed in 1986, no federal agency is actually responsible for oversight or regulation of the law. That leaves the primary regulatory authority for RRGs to its state of domicile. That has caused its share of disagreements and court battles. We spoke with Michael Schroeder here at the annual NRRA conference. He's co-founder and general counsel at Allied Professionals Insurance Company. He and Allied have taken a lead in the role of preparing court strategies with NRRA in order to protect RRGs from regulatory overreach. Here are the highlights.
Amicus curiae means friend of the court. And what Allied Professionals did is we worked with the National Risk Retention Association, and we decided to create a partnership where we would litigate key questions about state laws and whether they could be applied to risk retention groups. And the National Risk Retention Association would file friend of the court briefs in support of us so that the court knew this was an important issue. I think that the litigation phase is largely probably over. There may be a few outliers, but there were 5 cases that really established that only the state in which a risk retention group is incorporated can regulate them. The other 49 states can't. And now we've had Supreme Courts and state Supreme Courts and federal courts of appeal all come to the same conclusion. The only other major litigation that may come down the line at some point is some states charge illegal fees to risk retention groups. And I think at some point the RRGs may get together and pick out a state and litigate whether that those fees are in fact legal or not. The legal precedents that we established, they apply to the regulators already. The principle of law that we worked to establish was that if it's not specifically listed as something they can do, they can't do it, whether it's a state legislature or a state regulator. As I think the only remaining thing that you may see with the regulators is this question over fees. I think the future of the industry is very bright. I mean, they have over $12 billion now in admitted assets combined, which is a remarkable figure when this industry didn't exist 30 years ago. They have, each one of them operates in a niche that they very much understand and in areas that regular insurers either think are too small, too complicated to figure out. So markets will go hard, markets will go soft, pricing will get difficult, and it'll get easy. But the central need that the risk retention industry is filling is niches that other people don't want or can't figure out, and that's not going to change. And over time, this industry is going to get bigger, and I think it has a very, very bright future. The 2015 NRRA conference is important because what it does is it's the most successful one we've had, the highest attendance, the most sponsorships, and it is at a point where we're consolidating some of the victories that we've had and determining what we want to do when we go forward. There's talk about legislation that would allow risk retention groups to write property coverage, and there's some other initiatives that we're looking at. But this is a turning point conference, I think.
For more coverage of the 2015 NRRA conference, visit the RIN TV On Demand Library.